All right, ready to jump into a deep dive on contract law. And trust me, this is going to be anything but boring legalese. We're talking real-life stories, unexpected twists.
We might even throw in a chicken or two along the way.
Exactly. Our listeners send in a whole stack of legal readings, court cases, articles, all because
they're ready to decode contracts, make sense of those tricky clauses.
And that's what we're here for. We're breaking down the jargon, unpacking those key concepts.
Equipping you with the knowledge to navigate any agreement with confidence.
Whether it's signing a lease, sealing a business deal, or even just
satisfying that curiosity about how this stuff really works.
Think of it as your crash course in Contract Law 101, but way more interesting.
Much more engaging than reading a textbook, that's for sure.
Absolutely. So let's start with a concept that tends to trip people up. The parole evidence rule. Sounds kind of intimidating.
It does, doesn't it?
But it's actually pretty straightforward.
It is. Imagine this. You have a written contract, right? But maybe there were all these conversations beforehand, emails flying back and forth.
Maybe even some promises jotted down on sticky notes.
Exactly. And those sticky notes, they might not have made it into the final agreement. The parole evidence rule is all about figuring out when a court can look beyond that written contract.
Ah, so it's like deciding which evidence is allowed in a legal game of Clue.
Precisely. Were those side conversations really part of the deal, or are they like red herrings meant to throw everyone off track?
And that's where things get interesting, especially with a case you sent us. Mitchell v. Lath.
Mitchell v. Lath. A classic example of the parole evidence rule in action. And this one involves, would you believe it, an ice house.
Our listeners specifically wanted to understand this case better, so let's break it down. Essentially, we have Mrs. Mitchell buying some property.
But later on, she claimed the seller made a verbal promise.
A promise that wasn't included in the written contract. She said he was going to remove an ice house from a neighboring property.
That's right. And this wasn't just any promise. She argued it was a separate agreement, a crucial part of why she agreed to buy the property in the first place.
So she's saying there's more to the story than what's on paper.
Exactly. But in the end, the court didn't buy it.
They didn't side with Mrs. Mitchell.
No. They took one look at that written contract for the sale and said, this seems pretty complete. If the ice house promise was so important, it should have been in here.
Tough break for Mrs. Mitchell, but this highlights a crucial point for our listener. If it's not in writing, it's like it never happened, at least legally speaking.
Exactly. Don't rely on winks, nods, or those, but you promised. Please. When it comes to contracts, get it in writing.
Solid advice. But even when everything is in writing, there's still room for debate, right? And that brings us to the whole plain meaning versus contextual interpretation dilemma.
Ah, yes, the age-old question. Does a word in a contract have one single meaning, or does it all depend on the situation? And the legal world, as you can imagine, has some thoughts on this.
Okay, so for our listener who might not be a legal scholar, break it down for us. What's at the heart of this plain meaning versus contextual debate?
Well, the plain meaning rule is like going straight to the dictionary. You look up the word, take the first definition you see, and that's that. No need to overthink it.
Seems simple enough.
Right. If a contract says delivery by Friday, it means anytime on Friday. No need to make it more complicated.
Makes sense. But I have a feeling the context folks might disagree.
Oh, they do. Contextualists, they'd say, hold on a second. Words get their meaning from, well, the context. The situation, the relationship between the parties, maybe even things like industry norms. All of that can change how we understand a word. What if, in that particular industry, delivery by Friday is always understood to mean by noon on Friday?
Okay, yeah, I can see how that throws a wrench into things. Do you have a case for us where this what does this word really mean issue comes into play?
I do. And it involves a food that, surprisingly, causes a lot of legal headaches. Chicken. The case of Friedlaman Importing Kobe v. Vienna's International Sales Corps is a perfect example of this debate in action.
Our listener flagged this one, and I have to say, the situation is a bit foul. Set the scene for us. What's all the drama surrounding this chicken?
It all boils down to a contract, seemingly simple enough, for the sale of chicken. The problem: the parties involved had very different ideas about what kind of chicken they were dealing with. The buyer. They were expecting tender young birds, the kind perfect for frying up or grilling.
Okay, I'm already feeling for this buyer. What did they get instead?
Instead of those picture-perfect birds, they got a shipment of older, tougher chickens. The kind you'd use for stewing. Still technically chicken, but...
So it's like ordering a steak at a restaurant and getting a plate of ground beef. technically still beef, but a completely different experience.
Exactly. And this whole misunderstanding, just from the word chicken, it ended up in court.
Oh.
The judge had to decide. In the context of this contract, did chicken mean any type of chicken, or did it mean something more specific?
Okay, I'm on the edge of my seat. Did the judge side with the tender, chicken-loving buyer, or did the seller win this whole poultry battle?
So in this chicken showdown, the judge actually sided with the seller.
No way, they didn't get those tender birds.
They did not. The ruling was that the word chicken did include those older stewing chickens, and if the buyer wanted a specific type, well...
They should have been more specific in the contract.
Exactly.
Wow, talk about a harsh lesson in contract law.
It really highlights the need for precision. You can't just wing it, especially when chickens are involved.
So, to bring it back to our listener, if they're ever in a situation where there's confusion about what a contract actually means, what should they keep in mind?
Well, first and foremost, remember that courts, they're going to look at the entire contract, not just isolated words or phrases.
Right. They're trying to understand the bigger picture.
Exactly. It's about understanding the purpose, the intentions behind the agreement.
It's like understanding a complex recipe. You can't just look at one ingredient. You've got to consider all of them, the measurements, the whole process.
But fully appreciate the final dish.
Exactly.
And that's why having a well-written contract in the first place is absolutely crucial.
Absolutely. Now, what about situations where the words in a contract seem clear, but one party claims there was this side agreement, something verbal that changes things? How do courts navigate that?
Now that's where things get really interesting. Because it often becomes a battle between the written word and anything that was, said on the side.
Yeah.
Remember that parole evidence rule we talked about?
Yes.
Courts have to decide what evidence is allowed, what's relevant to understanding the real deal.
So sometimes it's about proving what was really agreed upon, even if it wasn't written down in black and white.
Exactly. And here's the thing. Different courts, different jurisdictions, they might have slightly different approaches. Some courts are strict, sticking to that four corners rule, meaning they focus solely on what's in the written contract. Mm-hmm. But others are a bit more flexible, willing to consider outside evidence, witness testimonies, industry customs, that sort of thing.
So it's a bit like those cooking competition shows. You've got one judge who's a stickler for technique, follows the recipe to a T. Then there's the other judge who's all about the creativity, the overall flavor.
That's a great analogy. And just like those shows, the outcome, well, it can sometimes depend on which judge you get.
That makes sense. But to be honest, it all sounds a bit overwhelming. Is there anything our listener can do to, protect themselves, to steer clear of these contract battles in the first place?
Absolutely. Like we've been saying, being clear and specific in your contracts is key. Define everything, outline all those expectations, don't leave anything open to interpretation.
So like the old saying, an ounce of prevention is worth a pound of cure.
Precisely. And of course, when in doubt, talk to a legal professional. A good lawyer can help you draft a solid contract that really protects your interests.
Solid advice. Now, you mentioned earlier how different places handle things differently. Our listener was curious about the Uniform Commercial Code, the UCC. How does that factor into all of this?
Right. So the UCC, it's a set of laws specifically for commercial transactions in the United States. It has its own rules for interpreting contracts, especially when it comes to buying and selling goods, which, as we've seen today, can get pretty complex.
So we're talking like contracts for selling a massive shipment of potatoes. The UCC would come into play there.
Exactly. And when it comes to the parole evidence rule, the UCC is a bit more flexible compared to common law. It allows courts to consider things like industry practices or the history of dealings between the parties.
Okay, so even if the written contract seems complete, those external factors can still come into play under the UCC.
Exactly. The UCC also really stresses good faith and fair dealing in business. It's not just about the letter of the law, but about making sure things are fair.
Which is always a good thing. Now, our listener specifically asked about something called merger clauses. What are those all about, and how do they fit into this whole contract interpretation puzzle?
Merger clauses, those sections you often see in contracts that say something like, this is the entire agreement, or this document supersedes all prior agreements. That's what we're talking about.
Okay.
They're basically saying that everything important is in the written contract. Any conversations, negotiations, promises that happened before, if they're not in writing, they're not part of the deal.
So it's like drawing a line in the sand. This is it. Everything else is irrelevant.
Precisely. They're there to prevent those he said, she said, battles later on. The message to the court is clear. Stick to the script. What you see is what you get.
But are they bulletproof? Can one party still argue that there were side agreements or promises that should be considered?
It can get tricky. Courts generally give a lot of weight to those merger clauses, especially in contracts between sophisticated parties who had lawyers involved. But there are situations where a court might still be open to considering outside evidence, even if there's a merger clause. It's not always a slam dunk.
Intriguing. So it's like those escape rooms where you think you found the final clue, but there's one more hidden lock to unlock.
That's a fun way to think about it. And this brings us to a couple of interesting cases our listener mentioned: Hunt Foods and Industries v. Dolliner and Columbia Nitrogen Corp v. Royster Co. They both dealt with the UCC and how much weight to give outside evidence.
Okay, let's dive into those. Hunt Foods first. What was the issue there?
Hunt Foods was a case about a company trying to buy another company. They negotiated an option to buy the target company's stock. The written agreement seemed pretty straightforward, but then the target company, they claimed there was a verbal agreement, a condition for exercising that option.
So it's like those buy one, get one free deals where there's always that fine print with the specific conditions.
Exactly. And in this case, the court actually allowed evidence of that verbal agreement, even though it wasn't in the written document.
Really? Even though it wasn't in writing?
They did. They decided it didn't contradict the written terms, but rather added a condition to it.
So even with a merger clause, it's not always set in stone.
Not always.
Yeah.
But then we have Columbia Nitrogen. That one was about a long-term contract for phosphate.
Phosphate. Doesn't sound quite as exciting as battling chickens.
Maybe not as exciting, but just as important in the world of contract law. In this case, the buyer committed to purchasing a certain amount of phosphate each year. But then the market price of phosphate crashed, and the buyer, they wanted out.
Oof, I can see why.
Right. So they argued that it's common practice in the industry to adjust prices and quantities based on those market swings.
So they were hoping to use that industry practice as a get-out-of-jail-free card.
Essentially. And at first, the lower court sided with the seller, saying, nope, the contract is clear, you're stuck with it.
Makes sense.
But then the appeals court came in with a plot twist. They reversed that decision, saying that evidence of the industry practice should be considered.
Interesting. But doesn't that make contracts less reliable if you can always argue that some unspoken industry understanding changes things?
That's a valid concern, and that's why the UCC stresses that evidence of trade usage or course of dealing should only be considered if it doesn't clash with the actual written terms. It's all about finding that balance.
So it's a balancing act, making sure those industry norms don't completely override what's written down.
Precisely. And that's what makes contract law so fascinating, finding that balance between certainty and flexibility.
Well said. Now, you mentioned another case, Southern Concrete Services, Inc. v. Mableton Contractors, Inc.
Right, Southern Concrete.
This one also had to do with buying and selling a specific quantity of something, right?
Yes, concrete in this case. Southern Concrete was going to supply approximately 70,000 cubic yards of concrete to Mableton Contractors for a construction project.
Okay. Sounds pretty straightforward. What went wrong there?
Well, Mableton ended up needing far less concrete than they initially thought, and they only ended up ordering about 12,500 cubic yards.
Oh, wow. Quite a difference.
Right.
Did they try to get out of the contract?
They did. Mableton argued that it's common in the construction industry for concrete suppliers to be flexible and adjust quantities based on a project's needs, as things evolve. They even said that Southern Concrete should have been aware of this.
So a similar argument to the phosphate case.
Similar. But in this case, the court sided with the concrete supplier, with Southern Concrete. They emphasized that the contract clearly stated that quantity, and Mableton couldn't just ignore that. Plus, the contract even had a clause saying that only conditions mentioned in writing would be recognized.
So that entire agreement clause acted as a shield, basically.
Exactly. The court's message was clear. If you wanted that flexibility, you should have put it in writing.
This really shows why it's so important to carefully review everything in a contract before signing.
Absolutely. Read every single word, and don't hesitate to ask questions if something seems unclear or even slightly ambiguous.
Our listener also pointed out the case of WWW Associates, Inc. v. Jean Contieri. This one seemed to touch on that plain meaning versus context debate again. What happened there?
You're right. WW Associates, it's a great example of how courts grapple with those two approaches. It involved a contract for selling property, And the contract had a clause that said either party could back out under certain circumstances.
So kind of a safety net for both sides.
Exactly. But here's where it gets interesting. One party claimed that the cancellation clause, it was only meant for them to use, not the other party.
Wait, so they were trying to say the context of the agreement, the intentions, should override what the clause actually said.
Exactly. They said during their negotiations it was clear the clause was meant to protect them from a specific risk. But the court wasn't convinced.
Oh no. So they were stuck in a deal they wanted out of.
They were. The court focused on the actual language of that cancellation clause, which said either party could cancel. They said the contract was clear, and that was that.
That must be so frustrating when you feel like the written contract doesn't reflect the real agreement.
It definitely highlights the importance of making sure everything is spelled out clearly in the contract itself. Don't rely on unspoken understandings, especially for crucial things like cancellation clauses.
Now, you mentioned a really interesting case before, in Re's State of Soper. It sounds like something out of a movie.
It does, doesn't it? This one involved a man named Idris Soper who disappeared from his wife and started a new life under a different name. He even remarried.
Wait, are we talking bigamy?
We are. When Idris Soper passed away, a dispute erupted about who should get his life insurance payout.
I can only imagine.
The big question was, who was his real wife? The one he left behind, or the one he was living with when he died?
What did the court decide?
In a surprising turn of events, the court sided with wife number 2.
Wow. They went against the legal definition of wife.
They did. They said that, based on the situation, it was clear who the deceased intended to benefit.
So sometimes context trumps even the dictionary definition.
Sometimes it does. It shows that courts can be flexible, especially when trying to honor the true intentions of those involved, even if it goes against the typical interpretation.
It seems like there's always more to the story than meets the eye. Now, we've talked a lot about the Parol evidence rule and plain meaning, but you mentioned a case, Pacific Gas and Electric Company, VGW, Thomas, Drayage, and Rigging Co. That one seemed to shake things up a bit.
Pacific Gas is a landmark case in California contract law. It basically said that no contract is ever truly unambiguous.
Wait, really? So even if it's written in plain English, crystal clear, there's still room for debate?
According to the California Supreme Court, yes. They believe words don't have fixed meanings, context always matters, and courts should be open to considering external evidence to interpret a contract.
So even the most straightforward sentence, depending on who's reading it, their background, lace?
It can be interpreted in different ways. In this case, it's had a huge impact on contract law in California, leading to a much more context-focused approach.
Wow, that's a big shift. How have courts and businesses reacted to this kind of approach, where there's so much more flexibility in how contracts are interpreted?
It's been a bit controversial, to say the least. Some people love it, saying it makes things fairer and prevents people from being taken advantage of based on technicalities. But others aren't so happy, arguing that it creates uncertainty, making contracts less reliable.
Flexibility versus predictability, a classic dilemma.
Exactly. And it's something that comes up again and again in contract law.
You mentioned another California case, Trident Center v. Connecticut General Life Insurance Co. Did that one also deal with the fallout from Pacific Gas?
It did. Trident Center was about a loan agreement. Pretty standard stuff on the surface. The borrower couldn't prepay the loan for the first 12 years.
Sounds pretty typical. What was the problem?
Well, interest rates dropped, and the borrower wanted to refinance to snag a lower rate. They argued that there was an understanding that they could prepay if they paid a penalty, even though that wasn't written in the contract.
Hoping for a loophole.
Exactly. And the court, citing Pacific Gas, decided they couldn't rule out the possibility of ambiguity or external evidence that might change how they interpreted the contract. So they sent the case back to the lower court to take another look.
So even a seemingly airtight contract can be challenged.
It can. And Trident Center really shows the potential drawbacks of that more flexible approach. It can lead to a lot of uncertainty and legal battles, even when the contract itself seems clear.
It's a double-edged sword. It can be good protecting people, but also cause headaches for businesses relying on those contracts.
Exactly. And that's why it's so important to be aware of how these different approaches to interpretation work and to be super careful when you're drafting your contracts.
Before we wrap up, you mentioned something earlier about how there can be multiple intentions at play in a contract. Our listener found some material from legal scholars Schwartz and Scott who discuss this. What's that all about?
Right, so Schwartz and Scott argue that people often have different intentions for different situations. Think of it like this. You might have a plan for what to do on a typical Tuesday.
Right.
But then something unexpected happens. Snowstorm, power outage, you name it, and suddenly that plan goes out the window, right? You've got a whole different set of intentions for those outlier situations.
So like having a plan A and a plan B depending on what life throws at you.
Exactly.
Yeah.
And they say courts sometimes make the mistake of assuming that how someone acts in the usual expected scenario reflects their intentions for every scenario.
Can you give us an example of how that might play out in a contract?
Sure. Imagine a contract where someone's buying, let's say, furniture.
Mm-hmm.
And in the past, they've always accepted deliveries that are slightly delayed. No big deal.
Okay.
A court might look at that and think, well, they don't seem to mind a little delay. They've always accepted it before. But what if, one time, that delay causes a major problem? Like, they're opening a new store and now they've got no furniture. Schwartz and Scott would say that those past deliveries, those weren't accurate reflections of the buyer's intentions if there was ever a significant delay.
So it's like those super long terms and conditions we all scroll through online. We just click agree without really reading.
Exactly. We agree to all sorts of things. But would we agree to those same terms if a real problem came up? It highlights the need to think about those unusual scenarios in advance and make sure the contract reflects your actual intentions.
This has been an incredible deep dive, and hopefully our listener is feeling empowered, not overwhelmed by all this contract law talk.
I agree. We've covered a lot, but the key is understanding how contracts work, how they're interpreted, and how to avoid those common pitfalls.
It's amazing how many legal battles seem to involve food. Speaking of, we have one more case our listener was curious about. Hegblade Margulies Tenneco, Inc. v. Sunshine Biscuit, Inc. Another food fight.
You could say that. Hegblade Margulies Tenneco, or HMT for short, takes us back to those tricky trade usages. But instead of chickens, this time it's potatoes.
Potatoes. Okay, our listener must really love their food-related contract cases.
Yeah.
What's the legal drama with the potatoes this time?
So picture this. A contract for 100,000 sacks of potatoes. A lot of potatoes. The buyer, Sunshine Biscuit, they argued that in the potato industry, that kind of quantity, it's not always set in stone.
Okay, so they were hoping they wouldn't be stuck with literally tons of potatoes.
Exactly. They said there's usually some wiggle room, some adjustments based on the actual harvest. But the seller, HMT, they said, hold on, our guy, he wasn't aware of this so-called industry standard, and we took that number seriously.
So it becomes a question of, can you claim ignorance? If you're not aware of an industry practice, does that get you off the hook?
Right. Can you just say, I didn't know, and walk away? In this case, the court said, not so fast.
Didn't work out for Sunshine Biscuit.
Nope. The court basically said that even if that one HMT representative wasn't personally aware of the practice, the company should have been. They were experienced potato people, after all.
So ignorance isn't always bliss, especially in contract law.
Exactly. Especially when it comes to those industry norms and expectations. You got to do your homework, understand the lay of the land before you sign anything. HMT really emphasizes that.
This whole discussion has been incredibly eye-opening. If our listener is feeling a newfound passion for contract law, that's great. But as we've seen, it's a complicated world.
It really is. Those contracts are more than just pieces of paper. There's a lot going on beneath the surface.
Exactly. So as we wrap things up, what are the key takeaways you hope our listener will walk away with?
Well, number one, clarity, clarity, clarity. When you're putting together a contract, be precise, define everything, and for the love of potatoes, make sure the document reflects the real agreement. Don't just assume things are understood.
Basically, channel your inner lawyer. Dot your I's and cross your T's.
And remember, even the clearest contract, it can still be open to interpretation. Courts have their tools and methods, but those aren't foolproof.
There's always that human element, that gray area.
Exactly. So anticipate those potential misunderstandings, those what-if scenarios, and talk to a legal professional.
Excellent advice. It's been a pleasure diving into the fascinating world of contract law with you.
The pleasure was all mine.
To our listener, thanks for joining us on this deep dive. And remember, when in doubt, consult with an expert. Until next time.